Elections are going to court. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. The courts, federal and state, are more involved in election than ever before in elections. This reflects directly the shattering of confidence in elections following the elections of 2020 and some of the elections of 2022. You remember my telling you, recommending a week after midterms that conservatives turn to the courts, as liberals did long ago? Now, Kari Lake in Arizona and Rayland Brunson and his brothers from Ogden, Utah, are showing American patriots across the land how it is done. Anyone, whatever outcome they favor in the elections or in these two lawsuits, should thank the framers of the Constitution. They separated the legislative, executive, and judicial powers into separate departments. Without that, confidence in justice of government, once shattered, would be as irreparable as Thomas Jefferson found it in 1776, and for many of the same reasons. Before I dive into this, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I have chosen for today, which quotes Aldous Huxley, yes, that one, as saying, facts do not cease to exist because they are ignored. How apropos. One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, you see the latest icon, the little heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click on that and leave me a tip. Any currency will do, so long as it's legal tender. Now, of all the midterm elections that took place on November 8, 2022, the one in Arizona justly gets the most attention. Reportage on this election and its aftermath comes variously from the Gateway Pundit, the Epoch Times, and me. Now, I told you the day after midterms that Maricopa County, Arizona ran a disaster of an election. I am an officer of election, and I can neither imagine nor accept the excuses the Maricopa County Boards of Elections and Supervisors are now making for an election that was so bad that the only way to certify it was to adopt the unwritten Twitter rule by which Twitter finally threw Donald J. Trump off its platform. What we say goes. And that goes double for Secretary of State Katie Hobbs, who threatened members of the Mojave County Board of Supervisors with arrest if they did not certify election results. As Ron Gould, chairman of the Mojave County Board of Supervisors, has specifically charged. Katie Hobbs certified the elections, including her own as governor. Immediately, her opponent, Kari Lake, sued to contest the results. On Monday afternoon, the Gateway Pundit summarized her demands. Chief among these are that the court declare Kari Lake the winner in the governor's race per ARS section 16-676, or else set the results aside per ARS section 16-676, or Title 42 U.S. Code section 1983, and then redo the election, excluding all improper votes and having a special master run it. And in any case, forbid Katie Hobbs or Maricopa Recorder Steve Richer to have anything to do with new elections. Now, what grounds does Kari Lake have to contest the election? Lake cites the following grounds, according to the Gateway Pundit. First, 59% of voting machines in Maricopa County precincts failed. Second, Runbeck Election Services of Phoenix, Arizona actually receives mail-in ballots from Maricopa County for processing. A whistleblower there revealed that Runbeck received nearly 300,000 ballots with no chain of custody. Witnesses described appalling sloppiness in the handling of ballots at that facility. Among other things, floor supervisors let employees add family members' ballots without documentation of any kind. Third, Maricopa County counted tens of or hundreds of thousands of mail-in ballots with mismatched signatures in violation of the law. Katie Hobbs won that election, if you call it that, by 17,177 votes. So what does that tell you? And most recently, officials added more than 25,000 ballots to the total after Election Day, and they cited neither law nor rule that permits that. If Lake could show any of the last 3 points alone, then she could throw the outcome into doubt. I've left a link in the description to where you can read her 70-page lawsuit, courtesy of the clerk of the court. Judge Peter Thompson held an emergency hearing on the matter yesterday, and at that hearing, the judge docketed the case for December 19th and gave Maricopa County until tomorrow to file a motion to dismiss. Incredibly, Katie Hobbs was a no-show at this hearing, although the judge had ordered her to appear. I've also left a link in the description to an audio-only recording of that hearing from rumble.com. Bear with it. It has mostly musical filler because they had technical difficulties. But toward the end, you get to the hearing and you hear the judge give all the rulings that I described. The Gateway Pundit article shared 6 tweets or threads from various people, including Christina Babb and one of Carrie Lake's accounts. I have links in the description to all of them. Christina Babb gives a complete schedule, as the judge ordered. Carrie Lake reports that the signature verification evidence is under seal because recorder Steve Richer and several of the supervisors are embarrassed. You see Carrie Lake calling out Hobbs for being a no-show, just as she campaigned from her basement, same as Biden did. And if you listen closely, you'll hear the county attorney complaining that a long drawn-out hearing would contemplate swearing-in ceremonies. The judge brought her up short, saying that this was neither the time nor the place for advocacy. Now, while Carrie Lake is pursuing her case in Arizona, and North Carolina House Speaker Tim Moore is pursuing his independent legislative theory case before the U.S. Supreme Court, well, that same Supreme Court has actually agreed to accept a pro se filing for its Friday morning conference next year. The case is Brunson versus Adams, docket number 22-380. I've left a link in the description to that docket listing and also to the best YouTube video I have found yet explaining that case in detail. Briefly, the Brunson brothers are suing Biden, Harris, and all 291 representatives and 94 senators who just meekly accepted the results of presidential electors without investigating certain serious questions. And I'll get into what those are later. They initially filed in a district court seeking to overturn the presidential election of 2020. The district court ruled that they didn't have standing, so this case hasn't even gotten to the merits. A year later, October 2022, the 10th Circuit Court of Appeals affirmed. So, Raylan Brunson filed an 18-page petition for Supreme Court review with a 71-page appendix. Solicitor General Elizabeth Prelugar, on November 23rd, waived her right to respond. The court then put the matter on the agenda for the next Friday morning conference. This conference will take place on January 6, 2023, 2 years to the day after the great event. This timing might or might not be significant because, after all, the court generally reserves Friday mornings for its conferences, except that in May and June they confer on Thursday mornings. The court, furthermore, is in Christmas recess, with no activity on its calendar until January 6, 2023. Nevertheless, law professor Tim Canova offered some interesting reasons why the Supreme Court would bother with a pro se case. I've left a link in the description to his commentary. Now, technically, anyone can sue in pro se, that is, without asking an attorney to plead for him. But court clerks commonly judge such case filings harshly. They cite every petty stylistic error as reason enough for their employers on the bench to dismiss such cases out of hand, which they usually do. But not this time. According to Canova, the court almost had to take this case because it raises a national security concern. The Brunson brothers, of course, seek not only to remove President Biden and Vice President Harris from office, they also want to remove 291 representatives and 94 senators who voted to certify those results and never challenged them. Now remember, Senator Ted Cruz of Texas was the most prominent challenger of them all. The Brunson brothers have two serious, perhaps insurmountable, obstacles. First, presidents and vice presidents are subject to removal from office only by impeachment. And likewise, each chamber of Congress may expel members from that chamber, but no one else has any such authority to so act. Second, the court already turned down one big challenge to the presidential election, and that was Texas versus Pennsylvania, which challenged the appointments of presidential electors in Pennsylvania and 6 other states. Now, I want to say a lot more about that Texas case because it sets the background for why the Brunson brothers did what they did. But first, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You're not alone. The fluctuating economy, employment issues, unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Now, whether you just want to collect rare and unique coins, or you want to take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. Now, about that Texas case. To paraphrase my favorite YouTube influencer in the entertainment field, one Overlord DVD, I am going to share with you something that came to me indirectly and allegedly from a low-level Supreme Court employee who says he literally pressed his ear to the door of the court's conference room when the Texas case came to conference. But since I cannot verify any of that independently, I must present it to you as unverified rumor and ask that you take it with a grain of salt. Now then, first, I don't even know whether anyone would have been able to hear voices through a closed door, whether or not anyone in the room raised their voices. But according to this source, Chief Justice John Roberts harangued his colleagues, gestured out the window overlooking First Avenue East, and roared that the court risked riots in front of the courthouse steps if they granted review in Texas versus Pennsylvania. Justice Clarence Thomas wistfully said, "Then that's the end of democracy, John." This much we do know. Positively, the court said it. The court voted 7-2 to deny review. Justices Thomas and Samuel J. A. Alito cast the dissenting votes. The source further said that when the justices filed out of the conference room, most of them, including Justice Amy Coney Barrett, were smiling. Nearly a year and a half after summarily disposing of that case, the court took up the case of Dobbs versus Jackson Women's Health Organization. We all know about the Great Leak, the final result, and the protests outside of Justice homes. These included the homes of Justices Barrett and Brett Kavanaugh. In fact, Kavanaugh faced the most serious threat. Somebody tried to kill him. All of which to say that the circumstances under which the Brunson case has come to the Supreme Court conference are anything but normal. Even if you don't believe the rumor about the conference, about Roberts ranting and raving and saying you want riots on the steps, you can believe certain police reports about what almost happened in Justice Kavanaugh's house. Thus far, the Brunson case is on a conference schedule, nothing more. 4 justices must vote to grant review, which would be more comprehensive if that's going to occur at all. So, why schedule a conference? And why might 4 justices grant review? Well, Professor Canova points to the outside the home protests ever since Dobbs. He also suggests that Democrats, knowing they will not be able to legislate next year, might push laws to limit the term of service of justices of the Supreme Court or any federal court, mandate that judges and justices retire from hearing all cases by a certain age, and enlarge the court from, say, 9 justices to 13, 1 for each circuit plus the District of Columbia. Now, look at the court's current membership. A retirement age of, say, 70 would force Justices Thomas and Alito to retire immediately. Chief Justice Roberts would have only 2 years and 1 month left. Enlarging the court would further create 4 instant vacancies. Sonia Sotomayor would have to retire in 2024, but President Biden would still be in office by then. These changes would give Biden, or Ambassador Susan Rice, just in case, 6 or 7 court vacancies to fill immediately. Another court vacancy would present itself after the second inauguration, and of the conservative contingent, only 3 justices would remain. The other 2 had to retire. As you can well imagine, Justices Thomas and Alito would argue forcefully to head those changes off at the pass. Conferencing Brunson versus Adams could be one way to tell the Democrats, don't even think about it. Professor Canova also offers reasons why Justices Alito, Barrett, Kavanaugh, Thomas, and Neil Gorsuch might want to take up Brunson on its merits. The lawsuit alleges not that fraud definitely decided the presidential election. I don't think anybody can prove that today. But that Congress knew perfectly well that serious questions existed not only about fraud, but also about election interference by a foreign power or powers, and did not bother to investigate. That, says Canova, puts them in violation of their oath to, and I quote, support and defend the Constitution of the United States against all enemies, foreign and domestic, close quote. We also see big tech firms being state actors, which recent Twitter file releases now confirm. And did Chief Justice Roberts really worry about Democratic constituencies exploding out of southeastern Washington, D.C. to riot outside the Supreme Courthouse door? Maybe he did, and maybe he didn't. But if he did, how much more might he fret about civil disorder coming from the opposite direction and exploding all over the country? Now imagine Clarence Thomas saying, I told you so, John, or words to that effect. Having said that, I must remind you, even Professor Canova has not shown by what authority the Supreme Court could remove a sitting president, vice president, and 385 members of Congress from office. But any finding in favor of the Brunson brothers would be the sharpest rebuke yet to a broken civil system. Even granting review would hit like a thunderclap. Surely the court knows this, and that they would receive a motion to submit the case without oral argument. But would they dare grant such a motion? I don't think so. I'm now going to war game this case, a thing that Professor Canova did not do. My hypothetical scenario actually begins this week before Congress adjourns sine die. The House passes the very measures Professor Canova fears. The Senate takes them up, and enough rhinos vote in favor, perhaps the same ones who voted for the Disrespect for Marriage Act, or at least enough of them to give the Democrats their 60 votes. So they pass, and Biden signs them in a Rose Garden ceremony. The Supreme Court, 5 of whose members would no doubt be in almost mind-clouding fury, confer on January 6, 2023. Apart from other cases on their agenda, they decide to grant review in Brunson versus Adams and schedule it for oral argument and issue a peremptory order to invalidate Congress' new court tenure and enlargement laws as unconstitutional. Promptly on January 9th, they publish those orders on their Monday morning order list. I can already hear a bunch of apoplectic legal commentators ranting and raving and screaming at the top of their lungs about the court getting out of its jurisdiction. Meanwhile, the briefs come in. 500 or more of them from the defendants in the original lawsuit and over 100 friends of the court. And the court does request a response from General Prelugar. The case comes to argument maybe on March 28th. Chief Justice Roberts, not wanting a disorderly public display, closes oral argument to all but parties and their attorneys. Raylan Brunson need not necessarily make a total fool of himself in the argument session. No doubt one of his friends of the court could coach him. But he has to stand before the court and face a withering storm of scathing, not quite reprimand from Justices Ketanji Brown Jackson, Elena Kagan, and Sotomayor, all asking in so many words, "How dare you?" But that's only because he must argue first. General Prelugar must argue next and face an even worse storm from Justices Thomas, Alito, and possibly the other 3 conservatives on why no investigation of possible fraud and even more probable Chinese election interference? And what about Twitter and Facebook being state actors? Finally, Roberts intones, "The case is submitted." And millions of people listening live over the internet gasp. What next? For the next month, not a whisper comes from the court. Then on May 1st, 2023, the same source that broke the great Dobbs leak breaks another leak. The date is doubly significant. May Day, the day socialists still observe to demonstrate against capitalism. And also the common pronunciation of the International Radio Distress Call, May Day, which in French is spelled M''AIDEZ and translates as "Help Me." Tellingly, the leak begins with Thomas J. delivering the opinion of the court and ends, quote, "The decision of the Court of Appeals of the 10th Judicial Circuit is reversed and the case is remanded for further consideration in light of the above. So ordered," close quote. Senator Ted Cruz of Texas gloats, "I told you so." Senator Mitch McConnell, the rhino from Kentucky, tries to hold a press conference, only to have his audience cry, "Boo!" on him, and he shuffles off the stage in shame. Now, what sort of display happens on the House side depends entirely on the bid by Representative Andy Biggs of Arizona to be Speaker instead of Representative Kevin McCarthy of California. Sadly, I'm going to have to end the game here because there's just no telling how this is going to turn out. To be sure, not all the defendants in Brunson will still be in office. Many retired or they lost re-election in midterms, and the Arizona Senate delegation might change. Or they might not, because Blake Masters foolishly didn't file an election contest as Kari Lake did. Still, lots of things need to happen for this case to turn out the way the Brunsons want it to turn out. The only way any senator or representative is going to leave the Senate or House under this circumstance is by resigning. No one's going to make them. It takes 2/3 of either chamber to expel a member from it, and they're not going to get 2/3. So one whale of a lot of people had to resign voluntarily. And those who don't resign, and we know the House will just carry on with its skeleton membership. Constitution will let them do that. We'll have to make a significant change in the speakership. All I will say along that line is to remind you that the speaker need not be a member. And then the skeleton House has to impeach Biden and Harris both, and a skeleton Senate must try the case before any state governors appoint any significant number of senators. Or maybe the skeleton Senate will refuse to let the swearing in of a bunch of senators designate even come to the floor until after the Senate has gotten the impeachment trial over with. You see how complicated this is getting? You know, I think we all know that in all likelihood this isn't going to work. But it would keep the issue before the public right through the election campaign cycle. And maybe that's why the legacy media are not uttering a peep about it. So you had to hear about it from the Gateway Pundit, the Epoch Times, and yours truly. Link in the description of the article, to the Carrie Lake lawsuit, to the audio recording of yesterday's emergency hearing in that lawsuit, to the 6 tweets about her election contest, to the docket listing for the Brunson case, to the video at least trying to explain it, to Professor Canova's commentary on it, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to oursilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel and a link to that other YouTube video explaining the Brunson case, and to my videos about the red wave breaking against seawalls, where I explain the debacle in Maricopa County, Arizona, and my video about the courts becoming the new conservative theater. This is Terry A. Hurlbut delivering another Declaration of Truth and reminding you to let the truth set you free.